Welcome viewers to the Personal Injury Law Show. My name's Tony Carbone, personal injury lawyer of 25 plus years experience. With me tonight I've got John Carancis, personal injury specialist.
Yes, specialist Tony.
Accredited specialist.
Good evening viewers, good evening Tony. I'm an accredited specialist by the Law Institute of Victoria in personal injury law, Tony.
And joining us tonight I've got Carolyn McGuinness, another WorkSafe work cover lawyer acting for plaintiffs.
That's
Give us a
right.
bit of a spiel about yourself, Carol.
Oh, I've been doing work cover for 5 years. I work in plaintiff law and terrific, love it.
Excellent, Caroline. But before we get into tonight's work cover update, Tony, what's in the news?
What's in the news, John, is this interesting story by Shelley Hadfield of the $15 million spent by WorkSafe and also the TAC spying on injured people.
Shocking.
Now,
I'm astounded. We've got a situation where, to be exact, viewers, WorkSafe, the Victorian Work Cover Authority, an arm of the Victorian government, has spent $13.7 million investigating and video surveillancing workers, Tony. What's going on here?
They followed about 6,675 people and there was about 90,000 injured workers in that financial year. But significantly, Carolyn, of all those people followed, there's only been 18 cases of fraud prosecuted. Do you think it's money well spent?
Well, it's appalling money spent. In fact, WorkSafe is always saying that they want to actually make the scheme much cheaper for employers, and yet they're spending money in that vicinity to chase people around for. And what they've only found, 18 cases of fraud?
Well, they've only prosecuted 18 cases of fraud, which is a very low number.
Absolutely.
Now, Tony, I'm astonished. Do we have a Big Brother state now, Tony? Is it 1984 revisited, where we've got Big Brother watching every person in Victoria that wants to make a work cover claim?
I'm not really sure what the criteria is, but they do seem to be following quite a few people. But for me, the thing that concerns me is the fact that TAC, to their credit, what they do is when they have a conference, which is shortly prior to a hearing, they actually disclose the surveillance they've got in their hands, Caroline.
Which is what should happen, in fact.
But on the other hand, you've got WorkSafe, that they only disclose what they deem appropriate, and they don't disclose in a lot of cases.
Tony, you and I see it all the time. They do not disclose video surveillance. They only disclose it as an ambush tactic at the hearing of the matter. Once in a blue moon, they'll disclose
That's exactly
something.
right. And I find that very disconcerting because I think that they should have a bit more trust in plaintiff lawyers looking at the surveillance film and seeing if it really damages a case. And if it does, you can then go to your plaintiff and say, listen, you're wasting our money, you're wasting the taxpayers' money, you're wasting the court's time. A lot of it's people shopping and spying on...
And just do it normal, everyday activities. In fact, they're very intimidated by it. Our clients tell us that they're constantly aware that there might be cars following them, taking footage of them, even in the front yard, picking up their mail. It's very intimidating for people.
It's intimidating, and also, especially when video surveillance and video footage is taken of our clients' children, Tony.
Yeah, look,
and
in very personal and private circumstances.
Exactly, and that's occurred quite often, hasn't it, Tony?
Oh, without doubt. And my biggest beef, John, is that I'd prefer that WorkSafe take the same line as TAC, and that is at least 4 to 6 weeks prior to a hearing, disclose what you've got in your possession. That way we can make informed decisions about what cases to go to court. That way we're not going to spend 3 to 10 days running cases at the cost to everyone, and just have a bit of faith in the plaintiff lawyers doing the right thing.
Absolutely. And the other thing I was going to say is that a lot of the surveillance is put to people in court, and they quite understandably, as our viewers would understand, is that they can't remember going to Bunnings on a particular day and picking up some bolts or a bucket and spade. I mean, and yet that's put to them in court, and they're questioned about it and their credibility.
And
that's right.
And Tony, we all know that in these instances, there could be hundreds of hours of video surveillance taken by the agent, by the work cover agent, yet 30 seconds is only shown in the courtroom.
And so the point you make from that is to have a true depiction of how the person is. They should really show all the surveillance.
Exactly.
And that would be a fairer indication of how a person is.
And that should be made clear to the court, which we try to do, don't we, Tony?
That's it. Look, let's keep this show moving and we'll come back to this issue another time. But as part of our update, we're doing this case of King and Amarco. It's a interesting asbestos case. Colin, do you want to give us the facts?
This was a 62-year-old machinist and fitter who is suffering from asbestosis. He was awarded over $1 million in the Supreme Court of Victoria. It was a huge payout by a jury. What's interesting in this case is he was exposed to asbestos dust over 40 years ago, in fact 1972. But what's really interesting in this is that he'd only been out to the premises on 3 different occasions, and so his exposure only happened over a course of a few hours.
He was there for, in fact, 6 hours.
That's correct.
6 hours. He went there 3 times back in 1972. He's attended this plant, and over 3 occasions for 2 hours per occasion, he's done work there. And in this period of time, he's been exposed to asbestos.
What are we
That's
saying here, guys? That it was an unworthy plaintiff?
No, he was
No, not at
extremely
all.
worthy.
Not at all. He was not warned as to the dangers, Tony.
But 6 hours, does that sound...
It's incredible. It just shows how dangerous this disease is, Tony.
So is it a case that... was he 6 hours enough, or
Well, in
Oh,
this
yes.
case,
was it that blatant?
Yes.
in this case, there was evidence to show that he hadn't been exposed in any other workplace, and that he was living primarily in a rural setting. And so, in the what's called the latency period of 40 years, he couldn't have been exposed to asbestos anywhere else except at James Hardie. And the conditions in their factory were described as being deplorable.
Exactly.
But what was most critical in this was that their chief medical officer had 5 years prior to Mr. King going out there issued a document which said that there was a clear link between asbestos and cancer, and that any exposure would lead to a risk of injury. So clearly James Hardie were on notice
We're aware of it.
of the dangers, and yet this man went out there and he wasn't given the protective equipment he should have been given.
He wasn't given a mask.
That's right.
He wasn't warned as to what could potentially occur.
Yes.
I'm very alarmed about this case for the simple fact that 6 hours of exposure has led to this fellow picking up mesothelioma, but just shows you, one of the things we're concerned about is that there's going to be a massive increase in asbestos-related cases to do with renovations.
Home renovations, yes.
There's a lot of old bathrooms and wash houses and things like that.
That's right, particularly in houses that were built between 1920 and,
1920 and 1960.
And they've found that the incidence is increasing amongst women, which is very concerning.
Living in Moonee Ponds, I'll explain that in a minute.
Tony,
living in Moonee Ponds, we used to live in a house that had the bathroom and toilet detached, and the sheets were asbestos sheets, and we've put holes in these sheets, and it's a bit of a worry because you just don't know if anything's going to eventuate in the future. Viewers, we've got to go to a sponsors break, so please stay tuned. We'll be back very shortly. Thank you.